The Labour Court has ruled that employers cannot dismiss an employee who has failed a breathalyser test. Now, it upheld a ruling by the Commission for Conciliation, Mediation and Arbitration that an employee's dismissal was unfair after he failed several breathalyser tests. The employee in question was dismissed by a mining company, and this was found to be substantively unfair, and the company was ordered to reinstate him with retrospective effect and benefit. Osborn Mulatudi is a labour law analyst with Molatudi Attorneys and joins us now. Good evening to you, Osborn, and welcome. I'm just imagining how this news will be received by people who might have been impacted by the effects of a breathalyser test and had their employment terminated. But this employee was dismissed because the breathalyser test came back positive, but the blood tests came back negative. So in this case, it seems to be a case of the employer acting too soon. Would you concur with that?
Indeed, partly. And good evening to you, Iman, and to your viewers. I think the employer here had a number of challenges which could have been resolved from the point of origin. The one challenge that the employer had is that during the disciplinary hearing, as per the judgment, when one analyzes the facts, is that a chemical pathologist gave evidence, the evidence which almost tinted in the employee's favor, to the effect that a breathalyzer in some instances can be faulty and thereby leading to results that in themselves can be faulty. And the second challenge was the fact that the employee was then, his blood was then taken to, pathologists for further testing, and that result came negative. However, testimony that was presented was that did not mean that there was no alcohol content in the employee, but that, there was no detection at that time, precisely because for a variety of reasons, that the employee may not have eaten 8 hours before or may have consumed something that contained an alcohol content unrelated. Now, the third challenge was, despite the fact that the employer had tested the employee twice on the same machine, and on the third one it was a different machine, and both results came positive, was, as I indicated earlier, the evidence that was presented by a chemical pathologist, which was to the effect that a breathalyzer test can be faulty. What this means is that as much as most employers would like to rely on breathalyzer tests, that does not necessarily mean that their results are conclusive evidence of that which you wish to prohibit as an employer in the workplace.
Right.
So there has to be corroborating evidence to that effect. Okay,
so Osborn, and as you say, there are some striations here, different things that we have to consider. But yes. I'm thinking of, and this employee works in the mining environment. We know it's a highly regulated environment. Safety is paramount, and typically they would have a zero tolerance policy against any kind of, inebriation, or in a context where you could have diminished ability. Are they required now to, what do they do if they subject their employees to a breathalyzer test and are concerned about the results? Do they withhold that person from duty until they can get a blood test? What practically must happen in a scenario like that?
The best way, and this most prudent employers do, is to regulate all these aspects in your disciplinary code and procedure, although you may not cover everything. So most employers, firstly, they rely on observation, and secondly, they will rely on the contractual obligations that the employee has towards them. For instance, if you are an employee employed to drive a hazardous machinery, a dangerous machine like a forklift driver, or you work in a very highly risky safety area, or alternatively, where employers will then have breathalyzer tests on standby as the employee report for duty. But at the same time, they will also reserve their rights to subject the employees to further testing, such as taking blood samples. Under those circumstances, our view is that an employer will then be able to sustain evidence that shows that the employee either reported for duty under the influence of alcohol or that he was under the influence of alcohol in the course and scope of performing his duties. I must say that in this particular case, the employer argued that it was not about whether or not the employee was intoxicated. The employer, in fact, had a zero tolerance policy towards alcohol. And in this instance, the breathalyser test had revealed that the employee had a certain percentage of alcohol content, and that is why they took a decision to dismiss him. And I need to stress, it wasn't about whether or not that employee was intoxicated and whether he was capable of performing his duties.
Right,
it was simply based on the policy wording. Yeah.
And that's right. So as a final, as a parting shot, and this is important for clarity, if the breathalyser test in a context where the code of conduct says zero tolerance, so any amount, any quantity, is problematic. What do those companies have to do now? I mean, of course, dismissal is the extreme, but in the moment, what can they do if it comes to the person being allowed to then resume their duties?
I think one other aspect will be the issue of consent, and to even provide that if an employer refuses to give consent to undertake an alcohol test in the workplace, that may also amount to a dismissible offense. But more importantly, and flowing from this judgment, I would imagine that most employers will then want to take blood samples from the employees in order to corroborate that which a breathalyser test has revealed, i.e. that the employee's alcohol content was above 0.00 to a certain extent. And on that basis, and including any testimony that may be presented by an expert witness, that the employer will then be justified in dismissing that particular employee after a fair process. Unfortunately, this was not the case, but I would imagine that this employer would want to take this decision on appeal to have final clarity on this issue once and for all.
Well, we'll be watching it closely because I think it has a big impact for people in the work environment, particularly where the code of conduct is a zero tolerance approach towards alcohol or drugs. Thank you very much for talking to us. Osborn Mulatudi is our labour law analyst tonight, just sharing his perspective on this recent ruling by the Labour Court that employers cannot dismiss an employee who has failed a breathalyser test.